Legal issues dealing with foreclosures. Helping a seller with a foreclosure requires real estate agents to navigate legal, ethical, and financial risks. Here are some common problems agents may encounter: legal and compliance risks, unauthorized legal advice. Foreclosure laws are complex, and giving legal advice without being an attorney can lead to legal trouble. Agents should refer clients to foreclosure attorneys when necessary. Violating anti-deficiency laws. Some states have anti-deficiency protections that prevent lenders from going after borrowers for unpaid balances. Agents must be aware of these laws to avoid misleading sellers. Breach of fiduciary duty. Agents have a duty to act in the best interest of their clients. If they fail to properly disclose foreclosure implications, alternative options, or potential scams, they could face legal action. Ethical concerns and scams. Working with predatory investors. Some investors seek to take advantage of distressed sellers with lowball offers or misleading agreements. Agents should vet potential buyers to protect their clients. Misleading marketing. Advertising a foreclosure property without disclosing its status or implying a quick, easy sale can be deceptive and lead to ethical violations. Conflict of interest. If an agent also represents an investor looking to buy the property, they must fully disclose their dual role and ensure fair dealings. Financial risks. Short sale complications. If the property is underwater, worth less than the loan balance, the agent may need lender approval for a short sale, which can be time-consuming and uncertain. Unpaid commission issues. If a foreclosure sale goes through, the lender, agents may struggle to collect their commission, as banks often have strict rules on agent compensation. Property liens and title issues. Foreclosure properties often have tax liens, HOA debts, or second mortgages. If these aren't properly addressed, the sale could be delayed or fall through. Emotional and client management challenges, seller stress, and unrealistic expectations. Distressed sellers may be emotional or in denial about their financial situation, making it hard to negotiate reasonable offers. Last-minute foreclosure delays. If a lender suddenly changes the foreclosure timeline or cancels a sale, deals can collapse unexpectedly. How to avoid these issues. Stay informed. Know state foreclosure laws, timelines, and lender policies. Work with legal and financial experts. Partner with foreclosure attorneys and financial advisors to ensure sellers get proper guidance. Disclose everything clearly. Be transparent about the risks, timelines, and process. Screen buyers and investors. Ensure buyers are legitimate and not taking advantage of sellers. Handling foreclosure listings effectively requires a mix of legal awareness, market expertise, and strong client management skills. Here's a solid strategy to navigate these transactions smoothly. Understand foreclosure laws and processes. Know your state's foreclosure laws. Each state has different timelines and rules for judicial versus non-judicial foreclosures. Stay updated on Arizona's foreclosure laws, since you deal with AZ real estate. Understand redemption and deficiency laws. Some states allow homeowners to reclaim their property after foreclosure, and others may hold them liable for unpaid balances. Educate and prepare the seller. Explain the process. Clearly, many sellers don't fully understand foreclosure timelines, lender negotiations, or short sale options. Set realistic expectations. The seller must be aware of pricing strategies, potential delays, and their financial responsibilities. Encourage legal and financial consultation. Sellers may need guidance from a foreclosure attorney or tax professional. Price it competitively for a fast sale run, a strong market analysis, CMA. Since foreclosure properties often need to sell quickly, price it slightly below market value to attract offers fast. Consider investor and cash buyer appeal. Investors love distressed properties but expect discounts. Weigh whether a quick, lower cash offer is better than waiting for a traditional buyer. Market the property. Strategically highlight the positives. Even distressed properties have selling points. Focus on location, lot size, or potential renovation opportunities. Target the right buyers. Market to investors, flippers, and buyers looking for fixer-uppers. Use pre-foreclosure and auction platforms. Websites like HUD Homes, Auction.com, and Zillow's foreclosure listings can expand reach. Handle lender communication and approval coordinate with the lender. If it's a short sale, you'll need bank approval before closing. Keep all paperwork updated to avoid delays. Negotiate deficiency balances and lien releases. If the seller owes more than the sale price, work with the lender to forgive the remaining debt. Proactively manage title and legal issues. Run a preliminary title search. Foreclosures often have tax liens, HOA debts, or second mortgages that could delay closing. Partner with a title and escrow professional. Ensure a clean title transfer by working with an experienced title company. Stay ahead of foreclosure deadlines. Track auction dates and sale deadlines. If the home is in pre-foreclosure, keep the seller informed about the foreclosure sale date. Push for a fast close. Cash buyers or pre-approved conventional buyers are ideal to avoid delays. Protect yourself as an agent. Avoid unauthorized legal or financial advice. Always refer clients to professionals when discussing legal implications. Use clear and ethical marketing. Avoid misleading terms like easy foreclosure buyout or promises you can't guarantee. Ensure proper documentation. Disclose everything. Get approvals in writing and keep records of lender communications. Bonus: build a network for more foreclosure deals. Connect with REO, real estate owned, asset managers. Build relationships with banks and servicers that handle foreclosure listings. Work with investors and flippers. Having a pool of serious buyers can help you close distressed properties faster. Stay active in foreclosure and distressed property groups. Join local and online communities to learn about off-market foreclosure deals. A borrower may not remove fixtures from a home before a trustee's sale. Facts: a lender has scheduled a trustee's sale for next week. The borrower intends to tear out various fixtures, including the sink, ceiling fans, wiring, cabinets, etc. Issue: is the borrower permitted to retain any of the fixtures, and if not, what risk does the borrower face by removing and retaining the fixtures? Answer: according to most standard form deeds of trust, fixtures are a part of the lender's security for the underlying loan. By removing and retaining the fixtures, the borrower is destroying a portion of the lender's security and taking something that they are not entitled to. The borrower risks federal prosecution for mortgage fraud and state prosecution for theft and defrauding a secured creditor. CARS, paragraph 13-2204A. A person commits defrauding secured creditors if the person knowingly destroys, removes, conceals, encumbers, converts, sells, obtains, transfers, controls, or otherwise deals with property subject to a security interest with the intent to hinder or prevent the enforcement of that interest. In addition, the borrower risks a conversion-based lawsuit from the lenders. Sue box title, style, default, box, color, 333, title, color, FFFF, radius, 3, class, content box. Quick quiz, fill in the blank. According to most standard form deeds of trust, fixtures are a part of the lender's security for the underlying DBM Fit B answer loan. Sue box: a homeowner may not replace upgraded fixtures with the original fixtures prior to a trustee's sale. Facts: after purchasing a home, the owner of the home replaced the original sink faucets and built-in microwave with upgraded fixtures. Prior to the trustee's sale, the owner removed these upgraded fixtures and replaced them with the original fixtures. After the foreclosure sale, the new owner, which is a bank, is demanding that the original fixtures be replaced with the upgraded fixtures. Issue: must the former owner return the upgraded fixtures? Answer: yes. Once the new fixtures were attached to the home, they became part of the bank's security. Arizona Realtor Magazine, September 2013, former owner of home, entitled to washer, dryer after foreclosure issue. The lender foreclosed on the home. The home was unoccupied at the time of the foreclosure sale, but the former owner left a washer-dryer in the home. 2 months after the foreclosure sale, the former owner of the home is demanding the return of the washer-dryer. Does the lender have to return the washer-dryer to the former owner? Answer: yes. The lender is required to return the washer-dryer to the owner, provided that the owner pays any reasonable storage and maintenance expenses incurred by the lender. Note: there are no statutory guidelines for the buyer's obligations regarding personal property left in the home after a foreclosure sale or any other sale of a home. Therefore, the hotline recommends that after a foreclosure sale or any other sale of a home, the new owner take photographs and an inventory, witnessed by 2 disinterested witnesses, of any personal property remaining in the home. After written notice to the owner of the personal property of the former owner should be stored for a reasonable amount of time, e.g., 90 days. At that time, the personal property can be sold or destroyed, unless the owner of the personal property requests the return of the personal property and pays reasonable storage and maintenance expenses. Alternatively, the hotline recommends compliance in good faith by the new owner with the procedures in ARS, paragraph 33-11370, relating to abandoned personal property of a tenant.